It was supposed to be a compromise, but next year the government is going to be collecting $41 in taxes for every dollar it spends. Was that a good deal for Republicans, or should they have walked away? Fox News senior judicial analyst Judge Andrew Napolitano joins us live. So, Judge, last night we wound up with a cliff deal that taxes a bunch of people who are successful in this country and ultimately does not cut much in spending, which was the whole idea behind the Republicans' plan.
It was the whole idea behind the Republican claim, Steve, and good morning and Happy New Year to you.
Thank you.
It's good to be back after a little holiday break. But Republicans caved last night, which is what is churning the acid in the stomach of a lot of us this morning who believe that Republicans were elected to shrink the government, to reduce spending, to stop the borrowing, and to lower taxes. And yesterday, in a rush to join the stampede started by the Senate and a drumbeat continued by the president since his re-election victory in November, they went along with raising taxes on the most productive and not getting any spending cuts in return. I mean, think about it this way. The president won. The president got a good majority, and he has his program, and he's faithful to his own values in November. Republicans also won in the House, and they won on the promise that they would do the opposite of what they did last night.
Right, and they have tried to, but with for instance, the Bush-era tax cuts, they were going to go away at the end of last year, which they did. And this fiscal cliff extends it for everybody except the most successful in the country. So had there not been a time limit on that, I'm sure the Republicans, you know, they'd still be working on keeping the taxes low and the spending cuts more significant.
It would have been nice if the Bush tax cuts had been permanent and didn't have the sunset, which was yesterday, theoretically. But to tax the most productive in society, to tax the wealthiest, to tax the people who produce the most will cause them to produce less. What will that do? Fewer jobs for people that need jobs.
Well, you've heard the President of the United States. He said, you know, the new effective rate for people making $400,000 is going to be essentially 40% of your income will go to federal taxes. Now, do you think the president would consider 40% fair, or do you think that number would be north of that?
We fought a revolution against the king and the parliament in Great Britain when taxes were at 3%. Now they want to take 40% from us. Do we work for the government, or does the government work for us?
That's a good point.
These are profound questions that were not addressed in the rush to judgment last night. And when Republicans raise taxes, they lose. When they cut taxes, they win. They rejected that truism yesterday.
Well, perhaps round one went to the president for 2013, but the next round is going to be, you know, we've got the sequester looming in 2 months from now and the debt ceiling debate. That's going to come over again, and the Republicans actually have the bigger hammer this time.
Now, that is an opportunity for the Republicans to save the republic. If they don't let the president borrow any more money, just don't raise the debt ceiling and force him to live within his means, like almost everybody watching this show now does. Don't spend more money than you take in. Do you think the government can do that?
I think they should.
Yes.
But do they? We just showed folks the number, and it's getting bigger. It's not getting smaller.
God bless you, Steve.
Happy New Year
to you. Happy New Year to you.
Great to have you back another year with the great Andrew Napolitano.
What we do know, however, is that this matter is far from closed. The fact that Governor Corbett now realizes, as do many others, that there was an inexcusable rush to judgment is encouraging. Joe Paterno's only guidance to us was to seek the truth. So bottom line, this whole legal mess is far from over.
To straighten it out, let's get straight to Fox senior judicial analyst Judge Andrew Napolitano. All right. The sanctions are an agreement between two parties, NCAA and Penn State. So how does the state of Pennsylvania have legal standing to sue?
It doesn't. You know, you can't just sue somebody because you don't like how they harmed a third person. And even though Penn State receives substantial monies from the state of Pennsylvania, the earth, the dirt that it's located on, and the buildings are not owned by the state of Pennsylvania. They're owned by the trustees of the university, one of whom happens to be the governor.
So how can he object to an agreement of one of his own entities?
He should have objected at the time the NCAA came to Penn State and
waited
said,
6 months.
Here's the report of your law firm. You hired Louis Freeh, the former director of the FBI. He and his law firm wrote this scathing report, and you accepted this report. You accepted it uncritically.
Why would he do this? Is he a little embarrassed that he, as a state prosecutor, waited 3 years before anybody in his office went after Sandusky?
I don't know what's in his head, but I do know the facts. Before he was the governor, he was the attorney general. In that time period, he did nothing about the rumors and whispers about Sandusky. He's been brutally criticized by his new attorney general, the woman who succeeded him in office. Look, Greg, you can't just sue because you don't like the outcome of a litigation or a dispute as to which you had no relation. If that were the case, the courts would be hearing lawsuits today that were filed 100 years ago.
I've got the lawsuit, want to ask you about it, but we've got to go to some breaking news right now.
Fox News alert and new reaction now to a story that's getting national attention. As a New York county clerk stands up to a Gannett-owned newspaper that's trying to shame gun owners, or at least that's what the critics believe, by publishing the names and addresses of those who own firearm permits. Now, the paper believes that in the wake of the Newtown school shooting, it has the moral and legal high ground to do this. And it's not backing down. It did it already in 2 counties, and now it's going after a third. But the county clerk in that third county, called Putnam County, north of New York City. His name is Dennis Sant. He is refusing to release the public records. He was here with me last hour and said he will not budge on this. What, if anything, would make you turn over the list?
You're going to have to bring me into court, sue me, and we'll just go the whole 9 yards on this situation. I'm not backing down.
Well, this is setting up a legal showdown. So how does that play out? Judge Andrew Napolitano is a Fox News senior judicial analyst. How does that play out? Because he admitted at the top of the interview that they have the legal right to the records.
Right. Megan, Happy New Year to you. Very good to be here. Thank you. Unfortunately, for those who want their right to privacy protected, there is a statute in New York which does mandate the public revelation of the names of those who have licenses to keep and bear arms. That's one side of this. The other side of this is public servants who are duty-bound to obey the law are also duty-bound to analyze the law that they are obeying and to determine which will create more havoc, which will impair more public safety, which will do more harm, which will do more good. Blind obedience to the law or a serious challenge of it. This particular county clerk, and I'm a partisan in this. My hat is off to him. I think the people that do have the gun licenses have the right to keep that to themselves for a variety of reasons. The safety of their families, safety of their neighbors, their personal privacy. He seems to me as a person who is seriously looking at the law and deciding whether this law that he took an oath to uphold is as relevant today as it was when it was written. And he recognizes in the question, the answer that he gave you to the clip you just ran, he recognizes that he might not have the final say on that. So he will establish this challenge. He'll say, I'm not going to blindly obey the law. I'm going to protect the privacy and the safety of those who have these guns. If the courts decide that I'm wrong, of course I'll go along with what the courts tell me.
He didn't exactly say that.
I think that's what he meant.
I think he was implied it, but he didn't actually say that he'll turn it over.
So we are probably going to see litigation. The newspaper will challenge him. He'll resist it. A trial judge will rule one way. An intermediate appellate court will rule the other way. And he'll probably go to the Court of Appeals of the state of New York, which is the highest state court in New York. And that court, which is not exactly filled with pro-gun individuals, will rule on this, and it will rule on the Constitution.
You don't even have to be pro-gun. You have to be pro-privacy, you know, and pro-safety. I mean, I can't get past the example of the woman who's been beaten by an ex-husband who'd like him to believe she may have a gun and now has had it broadcast that she doesn't. You know, I mean, it can't get past the victims of prior domestic or other violent acts who now have had it broadcast to the world that they don't have a gun.
Well, you pointed out a study that you read this morning.
MIT.
Correct. Which shows that when the bad guys, when the crooks see this, they move away from the neighborhoods where people can protect themselves and to the neighborhoods where people don't have guns.
Not all the criminals are stupid.
Correct. So the public safety implications here are absolutely profound.
So you see the position that Dennis Sant is in, because he doesn't want blood on his hands. You know, he doesn't want to be in a position where he gives over the name of somebody and then that person gets hurt. But it's a slippery slope when we let, you know, county clerks interpret, you know, which law they're going to enforce and which law they're not going to enforce.
That's why we have a judicial system, because the law can't mean one thing in one county in New York and another thing in another county in New York. But the law was written with the idea that everything the government does should be exposed to public view. We don't believe in government secrecy here. We believe in government transparency. But some of the information we give the government should be held secret. Our tax returns, by law, are held secret. Certain communications that we have with certain people in the government, by law, are held secret. These should be in the same category.
Can we, I apologize, but can we hold the judge over? Because I got several issues I need to discuss with him. I'm not done. All right, stand by if you wouldn't mind, sir.
I'm not going anywhere.
And this isn't just about Speaker Boehner and the tears. This is about some important stuff, and we'll be right back. Don't go away. And Judge Andrew Napolitano is back with me now. All right, so I raised this with the state senator, Greg Ball, the other day.
Right.
In court, you exercise your Fifth Amendment right not to testify, and then the judge has to tell the jury, and you can't hold that against him.
Right.
You cannot make a negative inference from that. So he protects the right. The right is meaningless if it doesn't then get protected. If the newspaper's goal really is to shame these people, and that's the allegation from the critics, but the effect may certainly be to shame, is there some obligation to protect the exercise of their Second Amendment rights?
There's a profound obligation on the part of the state to protect the exercise of the Second Amendment rights. And the Supreme Court recently ruled in two cases, one called Heller, one called McDonald, that the right to keep and bear arms is an individual right, doesn't belong to the government alone, it doesn't belong to the militia or the military alone, it belongs to individuals. And the government's job is to protect that right. So the county clerk whom you just interviewed is touring between a statute that on its face says all these records are open to the public, and a principle of constitutional law that says directly, as interpreted by the court, you must protect the right to keep and bear arms. You can't say...
This is going to chill the right.
Correct. You can't say, well, we'll let you have a gun, but we're going to tell everybody that you have it. And we're going to let people press their finger on a computer screen, and there will be a picture of your home. That is not protecting the right. That is inviting an invasion of the right.
Here's one of the reasons I ask you that, because there is an exception in the law that requires disclosure of the names if the people who are trying to get the names plan on selling them or releasing them for commercial or fundraising purposes. So they don't want them released to telemarketers, that kind of thing. So they try to protect you from the telemarketers, but they're not going to protect you from journalists who may not have your best interests at heart.
Look, when the law was written, we didn't have computers the way we have them today. You couldn't touch a screen and see a picture of the person's house. And when the law was written, it was intended, if these records are going to be released, we're going to tell you ahead of time we have to release the records. But with the immediacy of that information coming out today, this would be a profound violation of the right to keep and bear arms if those who do so, lawfully do so, have to reveal their identity to the world.
Yeah. And they had to give their home addresses. They couldn't do P.O. boxes. They had to give their home addresses when they got their gun permits.
They have to give a tremendous amount of personal information about themselves to the government. If all that information comes out, that will have the effect of people illegally owning guns, because they will still want to protect themselves, but they won't want to reveal all that information to the government and to the public.
Any chance Clerk Dennis can stall this, he and his bosses, in the court system long enough that if they are so inclined, state legislators here in New York might pass a law that ironically looks more like the law in Connecticut where Newtown happened, that does protect disclosures of this type?
Well, yes, this litigation is not going to be resolved overnight. The newspaper may want these names tomorrow, but if it files a lawsuit, you're talking about 1.5 to 2 years before there's a final decision on it. Anything could happen legislatively in that much time.
Although in New York State,
well, this is not Arizona, it's New York.
The crying. You love it or hate it?
I'm kind of an emotional
You are.
myself. I cry all the time. Not on air yet, but I sort of like it.
I like it too. All right, Judge, thanks for being here.
Pleasure, Megan.
Hey, the Constitution founded our great country. Back in a moment. Only kidding. I got more. But one Georgetown law professor says, so what? We should just scrap it.
In a recent op-ed, Louis Michael Seidman wrote, "The obsession with the Constitution has saddled us with a dysfunctional political system. Instead of arguing about what's to be done, we argue about what James Madison may have wanted 225 years ago."
So do our freedoms vested within the Constitution hold up against the test of time? Joining us right now is Fox News senior judicial analyst, Judge Andrew Napolitano. So this professor from down at Georgetown,
right,
he's saying let's just throw that thing out because it's old and no longer applies.
Well, let me start by saying he is a well-respected legal scholar. He's not just a crackpot. And some of what he says is, his argument is, people disregard the Constitution, so why should we pretend we still have one? That's about the best argument that he can make.
Right.
But what he really means is the government should be able to write any law, regulate any behavior, tax any event, as long as it's for the common good. We don't have that system here. If the government could do whatever it wanted, guess what would die? Personal liberty would die. Think of it this way. The purpose of the Constitution is to govern the government, to restrain it, to make sure the Congress writes the laws, the president enforces the laws, the courts interpret the laws. They don't do everybody else's job.
Limited government.
To limit power, to keep it from being concentrated in one place.
But, Judge, he doesn't just say that people disregard it, so what's the use? He goes on to say it's archaic, it's idiosyncratic, it has downright evil provisions.
Well, there were some evil provisions in the original Constitution which permitted the trade in human bondage, the slave trade, and which failed to outlaw slavery. We obviously took care of that with the Civil War and the Civil War amendments. But the Constitution is actually brilliant. It disperses power. It gives us checks and balances. It assures that too much power won't end up in one place. Now, there have been amendments to the Constitution, amendments by consensus, meaning the government has just done things and no one's objected. That's why there's so much power in Washington, taxes are so high, and the president can start a war, can write EPA regulations on his own, even regulations that the Congress has rejected. That's the fault of the Congress and the courts for not keeping him in check when he does that. I don't mean just President Obama. Right. This is a characteristic of modern-day presidents.
And he doesn't offer an alternative. Okay, we have the Constitution. Let's just forget it.
Let's go back to the Magna Carta.
The good professor is a Wilsonian, as in Woodrow Wilson, who honestly believed, this is in my new book, Theodore and Woodrow, how two American presidents destroyed constitutional freedoms. But they both believed that the Constitution did not mean what it said, and that the government could do whatever it wanted as long as its purposes were noble. Guess what? We don't have a monarchy. The government has to obey the laws that it has written, and the Constitution is the supreme law of the land. If you want to amend it, but you can't overlook it.
So take that, Professor Seidman.
Yes, Professor Seidman.
All right. Judge Andrew Napolitano.
Pleasure, guys. Allison, that is great red. It really is. Goes terrific with Kilmeade's blue.
Right. Poor Steve is left out. Yeah, he's got nothing.
This looks like it's March 17th.
Right.
You're just looking for an excuse to have a beer before lunch.
Or January 7th, Notre Dame, baby.
Oh, go Irish.
Right.
All right.
Thanks, Judge.
Well, President Obama has signed a defense bill that puts restrictions on transferring prisoners out of Guantanamo Bay and other military prisons. The president had voted to veto this bill. It contradicted a promise he made in his first term to close Gitmo down. But instead of a veto, he attached a signing statement claiming he still has the constitutional power to override the new limits in the law. So Judge Andrew Napolitano is a Fox senior judicial analyst. Thank you for joining us.
Pleasure, Patty.
So essentially there were add-ons to this defense bill that weakened the president's power to transfer detainees out of Gitmo and other places. And he said, I'm going to ignore those.
Yes,
can he do that?
The short answer is yes, he can, and he probably will. And modern-day presidents have done this all the time. The concept of the signing statement, which is a piece of paper in which the president puts his objections about the law as he signs it into law, actually began in the Reagan administration. President Reagan used signing statements to say, you know what, I like 90% of this, and I'm going to enforce 90%, but I'm not going to enforce the other 10%. Every president since then has done it. President George W. Bush did it 1,200 times. He actually signed a piece of legislation into law and said, I have no intention whatsoever of enforcing this. Can the president do that? Well, if the legislation takes away power from the president that the Constitution has given to the president, then the legislation is unconstitutional. Does the Constitution give to President Obama the power to decide where to house prisoners? Answer, yes. The prisoners are in military custody, and he is the commander-in-chief of the military. He tells the military where to go and where to house prisoners. Even if the prisoners were civilian prisoners in the custody of the Justice Department, he's the chief law enforcer of the land. He runs the Justice Department. He tells the Justice Department, the Bureau of Prisons, where to house prisoners. So this is an area of presidential decision-making immune from congressional regulation. And so what will happen if he closes down Gitmo in the middle of the night and buys a prison in Illinois so the state of Illinois can have some more cash to spend? and the prisoners end up in this formerly state prison in Illinois. Can the courts undo that?
Right.
They probably wouldn't touch it with a 10-foot pole, and they would say it's a political dispute between the White House and the Congress. Let them resolve it.
So Congress, which represents the people who
Right.
are elected to pass these laws, they pass the law. The president says, "Nah, I don't like that one."
Well, you know,
this
is a law which basically funds the Department of Defense for the next year. And it's a trick that Congress plays on presidents, is that it will add to laws that the president likes something that he doesn't like, so he'll be forced to accept the whole. The president doesn't have a line item veto. If this were New Jersey, Governor Christie could literally draw with a pen a line through the portions of the bill he didn't like, and only the part that he didn't mark out with the pen would become law. The president doesn't have that authority. So in order to have money to operate the Defense Department, he signs the whole law holding his nose. There's also a provision in this law that lets the military arrest people, Americans in America, and hold them without bringing them to a judge or a jury, or without filing charges against them. There are members of Congress who opposed that, but they voted in favor of the law because they didn't want to shut down the Defense Department. So this does cut both ways.
What was the motivation behind that item in the law?
This last item in the law, I think it was an effort on the part of politicians to show that they can be tough on terrorism, but it's a blatant violation of the Constitution, which clearly says the government can't take life, liberty, or property without due process. Due process means a judge, a jury, and fairness.
So that one might go to the courts.
That one, I think, would be invalidated by the court. As soon as somebody is arrested by the military and held and not brought before a judge, that one would be invalidated. But I think the president, even though it's going to upset a lot of people, could shut down Gitmo on his own without interference by the court and notwithstanding the law.
All right, Judge Andrew Napolitano, thank you as always.
Pleasure, Patty Ann.
While a growing number of states are fighting to make it a crime to pretend to be someone else online, a lawmaker in Arizona is now proposing a new law banning online impersonation because she says it can help fight fraud and identity theft. If it passes, Arizona would join about a dozen other states with similar laws. But some First Amendment rights supporters say the law could punish those who create parody accounts on sites like Facebook or Twitter. With us now, Fox News senior judicial analyst Judge Andrew Napolitano. Judge, Happy New Year. Great to see you, sir.
Oh, same to you, Trace. You know, these cases you send me, they're never easy ones.
My question, Judge, off the get-go was, aren't there already current laws on the books that kind of cover this stuff already?
Yes, there are, and it's one of the reasons that in the emails you and I exchanged earlier today, I argued against this statute. Look, there's a law in Arizona, it's a federal law, and it exists in all states that prohibits fraud. And fraud is lying or cheating, making a material misrepresentation, and somebody being harmed by it. Well, this statute would criminalize an attempt to pretend to be somebody else, even if there's no harm. So if I created the fictional person of Thomas Jefferson and created this fictional person and engaged in all kinds of political debate, pretending to be Thomas Jefferson, who's obviously dead, I could be prosecuted under this statute, even though no one was harmed by it, because I intended to trick the people with whom I'm communicating into thinking that I'm the real Thomas Jefferson. I would think the state has better things to do than get involved in this.
I know you talk about no harm, Judge, but we went back and we pulled up a case out of Texas where two 12-year-old girls created a Facebook account about a third 12-year-old girl, right? They used her name, and they sent out these threats in her name. And so this 12-year-old girl who they impersonated was then at risk because she was also threatened. So does that kind of win you a little bit more in favor of this law?
Well, no, Trace, because that is covered by the statutes that prohibit fraud, the statutes that prohibit threats, and the statutes that prohibit harassment. You see, what we want, when we mire ourselves in more laws than we need, we make things more complicated, more expensive, and therefore less free. When the laws on the books are adequate to address the evils that society has to address, we spend less and we are freer, particularly when it comes to the First Amendment. Government must only interfere with the freedom of speech in the most extreme of circumstances, where it's absolutely vital to save an imminent threat to innocent human life. This is not that case.
Yeah, and really, when you talk about these laws, it's kind of how these laws are interpreted, Judge. And so, you know, you can take these laws that are being passed now in 11 states, maybe 12, and it suddenly becomes something totally different.
Look, if a mother created an account in the name of her daughter and pretended to be the daughter, even with the daughter's consent, as a means of teaching the daughter how to use the internet, the mother could be prosecuted under this statute. I mean, this is just so wrong-headed because it doesn't require harm. It only requires that you do this. The linchpin of criminal prosecutions in America used to be harm. If there's no harm, there's no crime. Then governments started to think they could right any wrong and regulate any behavior they want. They took the requirement of the state to prove harm out of the statute. That's wrong. That allows the government to ensnare innocent people who don't intend and don't cause any harm.
Right. And the law continues to chase technology. Judge Andrew Napolitano. Judge, great to see you, sir.
Did I win you over, Gallagher?
Yeah, well, you always win me over, Judge, and this one I'm kind of on the fence.
Happy New Year to you and your beautiful family.
You too. Thank you, Judge.
Thank you.